And welcome to today's lecture. We'll get started in just a few seconds. I hope that this lecture finds you all healthy, safe, and well. Hopefully talking about the federal judiciary gives you something to concentrate on that isn't the news, isn't your Twitter feeds, isn't all the uncertainty going on around in the world. So let's go ahead and jump right in. So today, we're going to be talking about the federal judiciary, kind of completing our tour of separation of powers at the federal level. Today we're going to be explaining the design and function of the federal judiciary, the role and practice of judicial review, and then based on your readings from the Principles and Practice Reader from both Scalia and Breyer, in your discussion post this afternoon or this evening, you'll be comparing and contrasting different methods of constitutional interpretation. So let's get started by thinking about the structure of the judiciary. The first thing to note is that there is a distinction that's really important between civil and criminal courts. Civil courts are courts of what's known as litigation. These are courts in which people raise lawsuits against each other or against other entities such as corporations, governments. These are not trials of crime, but these are civil disputes, breaches of contract, some sort of unjust treatment, and these are plaintiffs versus defendants, and the remedies are civil. If you find in favor of the plaintiff, you cannot provide jail time as a punishment. In contrast, we have criminal courts, and these are when people are charged with a crime. These are prosecuted by the state or the federal government, and these can be punished with criminal remedies. You can be fined, you can be imprisoned, in states that have capital punishment, you can lose your life. And so it's important here to recognize that most of what we talk about when we're talking about the role of the judiciary into shaping public policy happens in this civil arena. We also have what's known as a dual court system, in which the judicial authority is divided between state and federal courts. Most civil suits are resolved in state courts, who hold jurisdiction over where the matter in question is. These can be appealed up to intermediate courts of appeals and further appealed to the state supreme courts. If, however, the question involves an application of federal law, further appeals can then be made to the Supreme Court. So that is this state side of this dual system. Additionally, we have a federal court system that we'll talk about in just a second. But the Supreme Court only has original jurisdiction in which they hear cases for the first time, in rare cases as disputes between states or between the federal government and a foreign national. And in all other cases, they have appellate jurisdiction, meaning that the Supreme Court is the ultimate court of appeals. And these courts often begin cases come before the Supreme Court. If they don't work their way up through the state system, they begin in the federal system. And they begin in one of the 94 different district courts. Appeals are then made to one of the 13 federal courts of appeals, and we'll talk about this in more detail in just a second. And then appeals can be made to the Supreme Court. Again, the Supreme Court doesn't have original jurisdiction over many things, so it's mostly a Supreme Appellate Court. But appeal to the Supreme Court is not automatic. The court must issue what's known as a writ of certiorari and agree to hear the case. Granting cert, as it's known, does not mean that the Supreme Court disagrees with the lower court's rulings, just that it will review the decision. Less than 10% of requests for review are usually granted, and we'll talk a little bit more about this in a second. Now, this framework, this dual court framework, was established by the Judiciary Act of 1789, and it established the basic structure of the federal judiciary. It's still followed mostly today, though there have been some changes. And in one of the first important cases heard by the Supreme Court, Chisholm versus Georgia, in 1793, the Supreme Court actually upheld the ability of federal courts to hear cases brought against citizens of other states and against other states themselves. However, this was ultimately overturned in the 11th Amendment that was ratified in 1795, and some of the language in that amendment includes, "The judicial power of the United States shall not be construed to extend to any suit in law or equity commenced or prosecuted against one of the United States by citizens of another state, or by citizens or subjects of any foreign state." So the 11th Amendment actually kind of reversed this decision. And so this is important to think about the kind of checks and balances that Congress can pass a constitutional amendment if it does not like the way that the court has interpreted the Constitution. And the Supreme Court itself was relatively weak until Chief Justice John Marshall, who was the fourth Chief Justice and served as Chief Justice from 1801 to 1835. And during his term, he really expanded and strengthened the power and authority of the court. And this is really important with a case that was decided in 1803, Marbury versus Madison. And here the Supreme Court asserted that it had the right and power of judicial review to strike down an act of Congress as unconstitutional. As your textbook notes, it becomes, if the courts find an action to be unconstitutional, it becomes null and void. And John Marshall, in his opinion for the case, said that this is the very essence of judicial duty, and it continues to be one of the most significant things that we think about when we think about the federal judiciary. However, this is not an explicit power in the Constitution, but it is obliquely referred to in Hamilton's Federalist 78, which we'll talk about in a second. So this is kind of already in the beginnings of the 19th century, we have the emergence of how the federal judiciary is going to work. So for a little bit more detail, there's 3 tiers to the federal court system. The first are the 94 U.S. district courts, and these are like the trial courts of the federal system. They hear cases, especially when they involve kind of they're not within the jurisdiction of any single one state. They involve questions of federal law. They involve federal agencies. These are first heard by the district courts. They're overseen by a single judge. Now, if the parties are unhappy with the ruling, they can appeal to one of the 13 U.S. Courts of Appeals. And there are 13 judicial circuits. And there's a rotating 3-judge panel that oversees these appeals. And we'll talk about this appeals process in a second, about what exactly is being appealed. These are often known as like the circuit courts, because there are these 13 judicial circuits. And ultimately, things can be then appealed to the Supreme Court of the United States, whose 9 justices, including 1 Chief Justice, who their decisions are binding, and they set precedent that all other courts have to follow. And often what happens is you'll have 2 different courts of appeals make 2 different rulings, and then the Supreme Court has to kind of settle that dispute. So the appeals process itself needs to be clarified a little bit. The first thing is that appealing a decision is challenging that the ruling was correct, but it's on the basis of law, not fact. And unless there's some error in the fact-finding process, the appeals courts are supposed to accept the facts as they are presented in the original trial. They're not trying to say that there was some error or factual error in the case. Instead, they're trying to determine whether or not the law had been correctly applied in this case, or if the law itself was constitutional. So, the appeals process begins with submitting briefs. Rather than having a full trial, the sides submit legal briefs outlining their arguments that are reviewed by the appeals court. There are brief oral arguments and questions, and sometimes there might be brief presentations, just about 15 minutes, and then they're asked questions by the judges hearing these cases. And these appeals can be held either by a panel or en banc. Most are heard by a panel within the appellate court of 3 judges, these rotating 3-judge panels. But occasionally, if there's a concern of inconsistent rulings, there'll be an en banc hearing in which all the judges of that circuit will hear the case. And as you can see, the 13 different circuits are geographically distributed. And so we, in California, are part of the 9th Circuit Court of Appeals. Now, there's a couple of different outcomes that can happen during the appellate process. On the one hand, the court may affirm the lower court ruling. They may basically agree with the result of the lower court. They could reverse the decision, disagreeing with the result of the lower court ruling and overturning that decision. They can vacate the decision, and here the court is, while reviewing the court outcomes, they overturn the lower court's ruling as invalid, but without necessarily disagreeing with it. This might be because the legal principle or the statute no longer exists or applies. Or they can remand a court, where the appellate court basically sends the case back to the lower court to be reheard. Now, given that these appeals are questions of law, we should think about the different sources of laws that these judges are trying to negotiate. So first, we can look at constitutions. Both the state and the federal constitution hold supreme authority and determine the scope and extent of powers of governing bodies. Judicial review can often turn on whether or not a law was authorized by a state or federal constitution. Most law, however, takes the form of statutory law, or laws passed by federal, state, and local governments. Part of what the courts are doing are interpreting these statutes and the meanings of these laws, where there are disputes or ambiguities, to ensure that they're being enforced and implemented as intended by the law. There are also administrative regulations. So when Congress, as we talked about last week, when Congress delegates authority to agencies like the EPA or the Health and Human Services or the CDC, the courts are often asked to interpret and review these agency regulations or agency interpretations of congressional mandates. Internationally, treaties, once they're signed and ratified, are binding on the federal government and creates legally binding regulations, and the states. So, for example, when the United States signed the Montreal Protocol on the ozone layer, and when it was ratified in 1988, it created legally binding regulations on chlorofluorocarbons and other ozone-depleting substances. Executive orders also have the force of law, even though they're not authorized by Congress, and so they are also subjects to judicial interpretation. The courts are also looking at other appellate court decisions because decisions made by appeals courts are binding forms of law on any lower court. So if you are if you are in a district court, you have to kind of consult the precedent that is set by the appellate court decisions. And ultimately, case law serves as precedent. Courts can cite previous cases and decisions to guide their current decisions on questions of interpretation. Cases can also provide certain standards, such as what's known, we'll talk about it in a little bit, known as the Chevron test, that governs how we should defer to agencies interpreting statutes. And judges are supposed to follow precedent according to the principle of stare decisis, which is Latin for let the decision stand. That judges are generally bound to obey previous precedent when the facts of the case are relatively similar, that there has to be significant changes to justify kind of changing this existing precedent. So why do we care about the judicial system and when we're talking about American politics? And Alexander Hamilton in Federalist 78 describes the importance of the judiciary, and especially the importance of an independent judiciary. He writes that the judiciary is the weakest of the three branches. This means it's always at risk of being overpowered by the other political branches. And he says that this is because it has no influence over either the sword or the purse. That it can't declare war, it can't authorize police actions, it can't authorize funding or spending. It's basically reliant on the other branches to achieve any of its goals. But he insists that an independent judiciary is necessary to safeguard what he calls a limited constitution. Or a limited constitution is one in which the authority of the legislature is not absolute. Congress can't simply legislate anything it wants. In Federalist 78, he talks about the fact that Congress can't pass ex post facto laws in the original Constitution. When the Bill of Rights becomes ratified, it means that there are other limits that that the Constitution places on Congress. And so an independent judiciary is necessary to safeguard these limits on legislative and executive action. This implies a power of judicial review because Hamilton writes that no legislative act, therefore contrary to the Constitution, can be valid. And so the interpretation of the law is the proper and peculiar province of the courts. In order to maintain separation of powers, the people making the laws can't be the same as the people interpreting the laws. He further contends that the independence of the judges is equally requisite to guard the Constitution and the rights of individuals from the effects of those ill humors with which the arts of designing men or the influence of particular conjunctures sometimes disseminate among the people themselves, and which, though they speedily give place to better information and more deliberate reflection, have a tendency in the meantime to occasion dangerous innovations in the government and serious oppressions of the minor party in the community. That the independence of judges is what preserves minority rights, that it prevents a tyranny of the majority. So how do we preserve the independence of the judicial system? Hamilton argues that judges should have a tenure of good behavior. This means that as long as they are not breaking the law or doing something impeachable, that they should have lifetime appointments. And he says that this is necessary to maintain the inflexible and uniform adherence to the Constitution. So because they're not going to try to appeal to political branches, whether the Congress or whether the president, in order to get reappointed, or if we had elected judges, to appealing to the people in order to get reelected. And so the whole idea here is that they are insulated from the day-to-day political processes, allowing them to make impartial decisions. Freeing them from political influence ensures the independence and hopefully depoliticization of the judiciary. So what exactly is this judicial review? So on the one hand, the court judicial review involves reviewing and interpreting the meaning of federal statutes. That they are often having to interpret ambiguous phrases in statutes. And we saw this in our discussion of the waters of the United States when we were talking about the Clean Water Act. Or there might be contradictory statutes. There might be conflicting interpretations by different district courts. The court is charged to interpret the meaning of the law so that it can be implemented both fairly and in accordance with the wishes of the law. So they're asking questions like, what does a statute mean? So if we're thinking about something like the Endangered Species Act that says you cannot harm an endangered species, the court has been asked in previous cases to interpret what harming means. Does it mean direct harm, or does it also include harming the ecosystem or the environment of an endangered species? The court is also going to review whether or not that statute violates the Constitution. So in recent years, we have the court reviewing parts of the Affordable Care Act to see if that violates certain aspects of the Constitution, mostly the Commerce Clause. But the courts are often reviewing agency actions as well. Is the agency's interpretation of Congress's law or their constitutional mandate correct? And so this is given what's known as highest scrutiny, that has the agency interpreted the law correctly. And in this question of agency interpretation, there's this doctrine known as Chevron deference. This is established in the 1984 case, Chevron versus a Natural Resource Defense Council. And the Supreme Court affirmed that where Congress has left the question silent, we should defer to the reasonable interpretation of the agency. The court may also review the agency's fact-finding, but this is given lower scrutiny than the agency's interpretation of the law, because the courts aren't really fact-finding investigative branches. They also may review the agency's use of discretionary power to apply, implement, and enforce the law. And here the courts have held that they will defer to the agency unless its action was deemed arbitrary, capricious, an abuse of discretion, or otherwise not in accordance with the law. So what exactly is the court doing when it's reviewing these statutes or these agency actions? Pretty much always, these are going to be civil cases. And so the first process is to establish standing, that who has the right to sue. And so the plaintiff actually has to establish that they were harmed in some way by the agency action or by the law in question in such a way that their constitutional rights were violated. But the plaintiff has to establish some sort of harm. And this can be injury in fact, that they have suffered or immediately will suffer an injury. This could be a question of causation. There's a clear causal connection between the injury and the agency action or the law that can be fairly traceable. And it has to be redressable, that it has to be likely that a favorable court decision will redress the injury. That if you can't actually solve the problem, if you can't provide compensation, then you don't really have standing to sue. Next, the court has to determine whether or not the case is ripe for review. Again, this is determining whether or not an actual injury or harm has occurred and not just a potential negative consequence. And this idea of ripeness was established in the 1967 case of Abbott Laboratories for Gardner, in which the majority opinion held, without undertaking to survey the intricacies of the ripeness doctrine, it is fair to say that its basic rationale is to prevent the courts, through avoidance of premature adjudication, from entangling themselves in abstract disagreement over administrative policies, and also to protect the agencies from judicial interference until an administrative decision has been formalized and its effect felt in a concrete way by the challenging parties. The idea here is that harm or a claim cannot rest on some hypothetical future. Were the agency to decide in this way, people would be harmed, but it has to be after the agency has already made a decision or taken an action. Next, the courts determine the standards of a review, or how much it will defer to the expertise of the agency in question. This involves how much authority regulators are going to be given and making their own interpretations. Finally, the court has to actually engage in the interpretation of the law. And this is not necessarily just calling balls and strikes, but is making an interpretation. There's going to be different ways that you can interpret the text of the law, different ways that you can interpret the intent or meaning of the law. They might look at congressional documents and records and statements. And they're also interested in consistency, making sure that the law makes sense in the context of other laws, as well as interpretations consistent with existing precedent. Finally, in making the ruling, the courts can award damages or remedies for harm, and generally, the judges have wide discretion in what remedies parties are liable for. And in cases of statutory interpretation, they may rule that a particular statute or portion of a statute is unconstitutional and is therefore null and void. So what about the Supreme Court itself, the highest and supreme appellate court? Well, again, they don't have original jurisdiction over most cases, so they actually have to select their cases and issue a writ of certiorari to hear a case that is being appealed from the lower courts. There is no automatic appeal. And this is usually based on what's known as the rule of four, that at least 4 of the justices have to request a review, have to agree to a review. At this point, both the plaintiffs and the defendants, and this includes the Solicitor General if it's a case brought against the federal government, will submit briefs. And in many Supreme Court cases, lots of interested parties will also submit briefs that are known as amicus curiae briefs. These are known as friends of the court, and they will try to inform and lobby the court, for lack of a better word, of how they should decide the case. Between October and April, the court will hear oral arguments, and these are more of a question and answer session than a formal presentation. The justices are asking questions. They've already read the briefs, they've already reviewed the relevant precedent, they're asking questions to the counsel for the plaintiffs and the defendants to try to get a sense. And often people can use these questions and the type of questions and who's asking questions to get a sense of where the court is leaning. Twice a week, when the court is in session, the justices hold a conference to make the decisions and determine who is going to write the opinions. And these conferences, when the court is out of session, are once a week, and these are often to determine which cases they're actually going to grant a writ of cert to. And the court decisions itself, as I've said, they set a precedent. And so here, the reasons for the ruling can be as important as the ruling itself. Court decisions will often cite the opinions that are given in addition to the rulings. And these can be the majority opinion. This is so when the 5 or more justices that vote in favor of a ruling, they will join in a majority opinion explaining their rationale, and that explanation guides for future interpretation of the law. Those who disagree will write dissenting opinions, arguing their case of why they believe that this is the wrong case, which also are part of the judicial record, even though they're not binding precedent. And justices who agree with the decision but disagree with the rationality can write a concurring opinion as well. So now that we kind of have a sense of what the courts are doing, it's important for us to now think about the politics of the courts. So what are and it's important to think of this both in terms of the political influences on the court, so politics as an input, as well as the court's influence on politics, so politics as an output. So one of the most obvious ways that the courts can be political is through the appointment process. Because the president nominates justices for life to the Supreme Court, any president is likely to appoint justices who agree with their political opinions and agenda. They do not want to appoint justices to the Supreme Court that are likely to strike down their agenda as unconstitutional, regardless of if you are a Democrat or a Republican. But the appointment process is also shared with the Senate, who has the advise and consent power. So even the most qualified justices may not be appointed if the president does not think that they are likely to get approved by the Senate. This is only intensified with polarization. For example, Antonin Scalia, who was one of the strong arch conservatives on the court before he died a few years ago, was approved by the Senate by a vote of 98-0. 98-0. More recently, we have the filibuster of Merrick Garland's appointment after Scalia died by President Obama, and then President Trump's appointment of Neil Gorsuch and Brett Kavanaugh, which were deeply polarizing appointment processes that basically were approved along party line votes. So the appointment process is going to shape who, and the politics of that is going to shape who itself is sitting on the court. Additionally, we also have to consider the justices' opinions themselves. Justices are people too, and as much as they say that they are neutral arbiters of the law, and as much as Hamilton talks about faithful and uniform adherence to the Constitution, their own political opinions can't help but influence their own decision-making. But if we think about politics more broadly and think about the institutional politics, the court also wants to preserve the legitimacy of the institution. Now, why does the court care about this? The court can't enforce its own decisions. It relies on the perception that its rulings are apolitical and legitimate to get the other branches of government to adhere to its rulings. The court doesn't have an army, it doesn't have the ability to tax, doesn't have the ability to write law, so it relies on Congress and the president to actually follow through on its rulings. And if it loses this sense of legitimacy, if people view that the court decisions are illegitimate, that they are partisan or political, then people will start ignoring court decisions. So often the justices are really concerned with ensuring that their decisions appear legitimate. This is why in Brown v. Board of Education it was important then that the court really the justices on the court made an emphasis to ensure that it was a unanimous ruling because they knew it was going to be controversial to strike down school segregation. They wanted to show that this is not a partisan or political ruling, but this was a united court. Similarly, many people now argue that Chief Justice John Roberts is primarily concerned about the legitimacy of judicial institutions. He's written several opinions, both in his court decisions and in the public press, about the importance of judicial independence, and many look to him as a kind of moderating influence who is going to work to preserve the legitimacy of the Supreme Court and offer more moderate decisions. But the court also influences politics. In its obvious way, rulings impact policymaking with real outcomes. For example, when certain provisions of the Affordable Care Act were struck down, such as the requirement of the Medicaid expansion, that changed the way that the Affordable Care Act worked. When the court decided in Citizens United that corporate speech counted as corporate donations to soft money groups were protected political speech, that changed the way elections were functioning. And so you often will hear debates between those who talk about judicial activism or judicial restraint. And judicial activism generally means the idea that the courts are becoming actively involved in policy making by striking down or amending the statutes. Where judicial restraint is often this idea that the courts are going to play a limited role. But often, what people call judicial activism and what people call judicial restraint isn't actually politically neutral, that people call decisions that they disagree with judicial activism and decisions that they agree with judicial restraint. Additionally, there's also this idea that was published in a 1991 book by Gerald Rosenberg called The Hollow Hope. And here Rosenberg argues that despite their popular perception that the courts aren't really good at achieving social change by themselves, but that because of things like Brown versus Board and Roe v. Wade, that they've become a hollow hope for social movements and activists that turn to the courts in order to try to secure rights. But ultimately, what actually secures the expansion of rights were congressional action, changing the actual laws. And that these movements are getting trapped into protracted years and decades-long legal battles in the courts, and when they should be focusing on expanding their movement, changing public opinion, and changing the law themselves. So if you think about Brown v. Board of Education, which struck down school segregation, it wasn't until actual Congress got involved and passed legislation and states took action to ensure this right that you actually had the true end of segregation, or at least legally sanctioned segregation. Similarly, you can see the opposite happen with Roe versus Wade, which affirmed the constitutional right to an abortion, but there is no federal statute securing this right. So many states have taken action to roll back reproductive rights, and roll back access to abortions and other forms of reproductive health care at the state level. So, we're not going to talk about the different ways of interpreting the Constitution in detail today, because I want you to take a look at the articles by Scalia and Breyer in the Principles and Practice Reader. And this is going to be the subject of your discussion post for this class. So to read these carefully and think about what are their arguments for judicial interpretations. Next class, we're going to talk about state and local governments. So you'll be reading Chapter 14 from the American Government Reader, and two short articles, one from the PP Reader on the Devolution Revolution, and one on the ways that cities and states have tried to take action against climate change despite federal inaction. So the discussion question, and I will have this question posted to the discussion thread shortly. Describe both Scalia's and Breyer's defenses of their own forms of constitutional interpretation. Which argument do you find the most persuasive? Not which of these you agree with the most politically or personally, but whose argument do you find more persuasive and why? So if you have an odd ID number, you're going to write a 200-word response based on the reading by 11:59 tonight. And if you have an even number ID number, you will write a 100-word reply to one of the discussion posts of your peers by midnight tomorrow. Thanks so much for tuning in for this lecture. I hope that this will help you focus on some schoolwork that's not just the coronavirus outbreak and pandemic and all the news surrounding that. This will give you something to think about. I hope that this information was clear. As always, if you have questions, hop into the discussion section or shoot me an email or schedule an appointment with office hours. Thanks again for tuning in, and I will see you next time.